You're listening to The Trial Lawyer's Handbook, a courtroom preparation podcast series brought to you by Holland Knight. This series is hosted by litigation attorney Dan Small and is based on a long-standing article series he co-authored with United States District Court Judge Dennis Saylor for Massachusetts Lawyers Weekly. Listeners of this series will gain a fresh perspective on how attorneys can address various trial preparation issues and set themselves up for success in and out of the courtroom.
Chances are you didn't grow up speaking like a lawyer, but from the time you started law school, you have been consumed with a new and strange language, especially once you began working with other lawyers who have also been consumed. You've been immersed in legalese, and whether you realize it or not, all kinds of legalistic words and phrases have probably crept into your speech. Consider just as a few examples: subsequent to instead of after, prior to instead of before, held a meeting with instead of met, on that occasion instead of then, with regard to instead of about. One of the most important rules of trying cases is to remember and to respect your audience. This is not a committee of highbrow lawyers. It's a jury, normal people. Think about occasions when you talk to normal people, family gatherings, strangers at a bar, whatever it is. You wouldn't talk to them that way, or if you do, that's a separate problem. Indeed, those are the people you should talk about your case with and listen to their questions, and those are the people you should be thinking about when you are speaking in court. If you want to try cases effectively, you have to weed out all that stuff out of your vocabulary. Use plain English. Don't use words that are more complicated than what you need. Legalese isn't just pompous and unnecessary, it's also confusing. Here's an example from an actual trial. Question: under what circumstances did the defendant come to give you this check? The witness looks confused. Do you mean, why did he give it to me? The lawyer looks sheepish. Yes. The witness gives an answer. If the witness is correcting your questions, it's probably not a good sign. Because if the witness is correcting your questions, the jury is not understanding them either. Sometimes legalese and occupational jargon come together for a 1-2 punch. Here's an example from a trial of a construction case. Did you invoice the surety for partial payment pursuant to the ratified subcontract? Consider instead, did you send a bill for your work? Where did you send it? Some people view the bar as a form of mystical priesthood with its own special language and rituals. They may feel that an important part of being a lawyer is knowing the right incantations to be trotted out at the right times. Not all phrases can or should be eliminated. Some are necessary or serve as important signals to the judge. For example, the lawyer may ask a witness whether there is something that might refresh his memory. In a normal conversation, you'd probably say something that would help him remember. But you use the legal phrase to make sure the judge understands exactly what the lawyer is trying to do under the rules. Nor is all ritual language undesirable. For example, because a trial is a highly formal event, the use of some formal language lends an air of gravity and dignity to the process. Similarly, the use of phrases such as "Your Honor" or "May it please the court" serves to show respect for the court and the process. Other legalese is simply an essential part of your case. There's really no good substitute for standard of care, even though, without your help, most jurors don't really know what the heck it means. But don't incant legal words or phrases just because they sound lawyerly. Most of them serve no real purpose, and at best, they waste time. What they really do is to distance you from the one group you want to be closest to, a jury of your peers.
Thank you for listening to The Trial Lawyer's Handbook, a courtroom preparation podcast series brought to you by Holland Knight. For more information on courtroom preparation, please email dan.small@hklaw.com or visit hklaw.com/Daniel-Small.